Thank you, Mr. Speaker and ladies and gentlemen. I am pretty confident and proud to bring that trophy back to ICU, which we have dominated for so long, ladies and gentlemen. The problem we see in the government is how justice given right now is disproportionate and is actually unjust, because it is not reflecting the true intention of these criminals and the past actions. We believe that there are connections which has to be made by justice between past crimes and this crime committed right now. And we believe in the government the best possible punishment is given when judges have access to maximum amount of information possible. This is what we believe in, and that is why we like to propose. What is our model? All liberal democracies, countries like Japan, US, would implement this policy and would allow judges and allow the courts to use the fact of that this criminal was given a punishment, and also what kind of punishments, and also the sentences given by the judges of past courts. And this policy would apply in all crimes, as the motion states. So it would apply in white-collar crimes, and also crimes like assaults or sexual assaults, or even petty crimes like stealing. We're going to bring you two things from government bench, ladies and gentlemen. Firstly, I'll talk about how this policy better achieves justice from the aspect of proportionality of punishments. And secondly, I'll talk about how this policy is beneficial from the aspect of deterrence. So firstly, justice. It's kind of a vague word, but I'll talk about that deeply. Now, the premise of this point, the premise of this debate actually, is that punishments shouldn't be randomly given, ladies and gentlemen, because punishment has a significant impact to these defendants, these criminals, and the society. And that's why courts are held. Courts are not only held, they are held really long, and there are constant debates between lawyers and prosecutors. And under long discussion, under long debate, these punishments are given, solely because punishments are really important and justice is important. Now, no, thank you. Having that said, the status quo we see on the government is unjust because punishments given right now are not proportionate to the crimes committed. There are both cases. One scenario is that the current court gives excessive punishments, not reflecting past crimes, or gives too light punishments, which is also not reflecting past crimes. No, thank you. Let's talk about first scenario, a light punishment being given. So there's a man who steals, or even who kills someone because they were suffering from poverty, that they were raised in an economically impoverished area. They were tried in the past. Again, these people came back to the society and again committed a crime due to the same reason. Under the status quo, courts doesn't have access to these past courts. No, thank you. And therefore, courts decide that because these criminals were from an economically impoverished area, this criminal is not inherently evil, but was driven by the environments around them. As long as society can tackle this problem, maybe we can solve this problem. Okay, yeah.
Even in the status quo, we allow past crimes to be used to give harsher sentences, right? Second offense is always harsher than the first offense. Why do we need to take this proposal to affect the verdict as well as the sentencing?
But firstly, I'll talk about the opposite case, how lighter punishments would be given under our policy. But they don't have full access to these discussions, which was done in the previous courts. There would be a change under our policy. So what would happen is that under the status quo, lighter punishment is given because court judges would think that they were not inherently bad, but were driven by environment. Under our policy, this criminal, which has committed a crime due to the same reason, judges would think that it was not of that of the environment which crimes was committed, but rather his intention was bad. That this criminal have lesser capacity to rehabilitate it in the future, and therefore this person should be imprisoned longer. So the punishments which would be given would be proportionate to that of the intention of these crimes. The opposite case is what, for example, man commits a crime in the past. He was he was decided that he was not inherently bad, and he was rehabilitated. And then he commits a crime. No, wait. Oh, it's the opposite. I'm sorry. So man commits a crime, and right now, because the courts doesn't think about the possibility of rehabilitation properly, it is excessively infringing the rights of these prisoners. They would be in prison, these prisoners, for 10 years or 15 years. But if courts have access to these information of the past, have access to these sentences and the decisions made by these judges in the past courts, then they can decide that maybe because rehabilitation had worked, maybe we can imprison these criminals shorter, or can give different rehabilitation program. So judges would have more information to give right punishments and proportionate punishments. And we think that in the case of criminals being imprisoned long is an incredibly wrong thing. Because if you are imprisoned, one, you would be taken out, you would be deprived of a fundamental rights like right to freely move, and also secondly, criminal record would remain, which means that it is most likely that these criminals would commit a crime again. Also, in the case of lighter punishments being given right now, and how harsher punishments would be given under our policy, we would be able to prevent second offense, and we think that's important because people who have not consented to crimes, would not be harmed by these crimes. So that under both scenarios, it is beneficial to its people. No, thank you. And we're not saying that judges would randomly use these past verdicts, these past information from past courts. If judges think that there is a strong correlation made between the crime committed right now and past crime, then they would consider that. And we think judges are rational in many cases. Even if we're talking about countries which has adopted jury system, there are mechanisms to prevent that there are no irrational decisions, like covering grotesque images, etc. Quickly on to the second point. We think that this policy also is beneficial from the aspect of deterrence. Because what is happening right now, especially when we are talking about crimes which was committed rationally, like white-collar crimes, there isn't much deterrence towards these criminals. Under our policy, if rationality would be revealed by the current court, then these criminals would be punished severely. So there's an increasing incentive for criminals to behave better once they go out of prison and go back to society. And we think this is obviously beneficial because I think both sides can agree that lesser crimes is important. So, Mr. Speaker, we think that justice and proportionate punishments are best given in the environment where judges have access to maximum amount of information. The burden of proof, the opposition, is to deny that, and for these reasons, we propose. Thank you.
Within 8 minutes. You're here.
Mr. Speaker, Prime Minister seems to be confident of taking the cup home because of past experiences. Maybe it's time for a change, right? Because his conceptions of that is based on the fact that ICU have won it previously and therefore they'll win again. Right? We believe that that's the same kind of concept which they're talking about in this debate. Because people have committed past crimes, they're probably going to commit crimes again. Mr. Speaker, on our side of the House, we believe there is a clear difference between sentencing, which is the degree of guilt, and verdict, which is about whether you are guilty or not. And in order to preserve the presumption of innocence, which is a very cherished criteria in our democracy, we are extremely proud to stand on the opposition bench. Before moving on to substantive, several pieces of rebuttal. Okay, I can't help but think that Prime Minister is already talking about something that we implement in the status quo. Because Prime Minister is mainly talking about how we are going to get proportionate punishment, whatever that is. But we already allow sentencing to be affected by prior offenses. That is why second punishments are always harsher than the first punishment. We already allow these kind of information to enter the decision-making process of the judge and the jury when it comes to sentencing. We don't see any change from making this proposal in the status quo and after plan in order of benefit. What we do see is potential harms, but more on that later. Second, they talked about how with taking this proposal, they'll be able to check whether the rehab system worked or not. Okay, fine, check that. But why do you blame whether the rehab worked or not on the criminal? You're forgetting that by using this sentence, you are putting the weight on the criminal when it's actually the fault of the state. It's the state who provided that framework of rehabilitation. If that didn't work, that's the fault of the state. That's not the fault of the criminal. And you can't just put responsibility on the criminal because we believe that's just unfair. So moving on to the second point. Mr. Speaker, we have 3 points to discuss. First, when do we allow prior convictions to be a factor in decision-making processes in relation to the presumption of innocence? Second, how this is going to cause more false sentencing and harsher sentencing. Third, my partner is going to talk about the rehab program of the liberal democracies. First, we believe that we already apply much of the benefits posed by Prime Minister in the status quo when we affect sentencing. This is about the degree of guilt. Obviously, if you have committed a past offense, then it is quite just that you should be punished more. So we believe, therefore, that it is important that we allow these kind of past conceptions to come and have a role in the decision-making process of sentencing. However, Mr. Speaker, what this motion essentially talks about, when they say evidence, it implies that it is used for verdict, which is about absolute guilt. Were you guilty or were you not? Now, we have several things. First, we believe that prior offenses is a very strong preconception. We believe that if people are naturally think that if you committed a past offense, you're more likely to commit an offense now. No. And we believe that this is a very strong point, which shouldn't be affected, because it's about your past experience. In the same way that other preconceptions are not allowed in a jury trial. A black defendant is allowed to veto a member of the jury who is a white supremacist, because the preconception is that these people are going to give a guilty sentence no matter what. So we believe that this kind of eradication of preconception is already happening in the status quo. 2, we don't call into question these kinds of evidence because it is not decisive. We believe that, right, there are several things which are decisive. Fingerprints, witnesses, DNA, and so forth. What we don't see is past crimes having any role, because there are 2 assumptions. 1, if you get out of jail, you have rehabilitated enough. And if you haven't rehabilitated, as I told you in my refutation, you shouldn't use it against the criminal. You should use it as a fault of the state that they didn't. Yes?
Okay. The consequences of the status quo is that there are more second offences happening and therefore harming society. That is why the state is taking responsibility and
then
changing
the problem is
quo.
obviously lying with the harsher punishment in second offence when it comes to sentencing. Why are you expanding the status quo to say that we should use prior offences as evidence in verdict as well? All the problems from proposition can already be solved within the framework of the status quo without affecting verdict. And why do we affect verdict? Because we told you, it's a very strong preconception. It hurts the presumption of innocence. The role of the state is to prove that somebody is absolutely guilty. We believe that people are innocent until proven guilty. These preconceptions compromise that. These preconceptions tell the judge, this guy might have committed a crime. We're based on no foundation of absolute evidence like fingerprinting or DNA. We believe this is totally unjustifiable in our criminal justice system. Moving on to the second point. Mr. Speaker, they've already admitted, practically, that people are going to be tried more. What they didn't tell you is that this is not necessarily going to be fair. Right? Status quo is very fair, because there is no such thing as prior convictions entering decision-making processes concerning verdict. People rely on good evidence, witnesses, DNA, fingerprinting, so forth. But what we tell you is that this is going to allow the state to cut corners in this kind of things, right? Because the preconception is so strong that now people are going to take circumstantial evidence as good absolute evidence. It might be something that, you can't prove that this witness might have witnessed it or might not have witnessed it. Or this person had an alibi. You might believe it, you might not believe it. But because now you have this preconception that this guy is guilty, they are more likely to think or take that preconception and circumstantial evidence. That means, Mr. Speaker, ladies and gentlemen, people are more likely to be proven guilty if they have a second offense, first offense, after taking this proposal. Several things.
Sir.
No. We believe that, again, just because somebody has committed a crime, it doesn't mean that somebody will commit a crime again. It's just the same as first offense, right? Just because you have been innocent up until the point that you might have committed a crime, it doesn't mean that you are innocent and totally not guilty of the crime. You don't look at whether there was a past record of innocence. You look at whether there's a present record of guilt. But we believe this bypasses that. And second, what you have to realize is that if these mistrials occur, as we've already told you, in the status quo, second offense punishments are much harsher than first offense punishment. Right? Rape for first offense might be jail time. Rape for second offense might even be punishable by death. You're looking at harsher sentencing of potentially the wrong people in our society, because this preconception is so strong and this preconception plays such a vital role in our decision-making process. Mr. Speaker, we believe that it is far better that we don't convict an innocent man of a second crime. We believe in the presumption of innocence. We believe in the integrity of our legal system, and we have never been prouder to oppose.
Thank you, Mr. Speaker. If opposition accepts that to some extent, especially in the form of the sentences, past records should be considered, we think it is fundamentally unjust for that to not be reflected and to be extended into when the judges decide whether the person is guilty or not in the first place, ladies and gentlemen. Because even if we accept that to some extent in terms of sentencing, these kind of things are reflected in the status quo, there are some cases in which somebody who is guilty, who has committed a crime, but when there is no other evidence, is running away from that justice, ladies and gentlemen. The problem still exists, ladies and gentlemen. And what I'm going to tell you in my speech is exactly that there are cases in which guilty and non-guilty is decided unjustly based on the lack of information, lack of evidence, and we think that it's fundamentally something that we have to change, ladies and gentlemen. They have told us that rehabilitation and all this kind of thing failing is a fault of the state. Ladies and gentlemen, I told you in the point of information is that we do accept that to some extent. That's why we're proposing a change, ladies and gentlemen. We think we are addressing that as well. We are exercising state responsibility. We have no problem. No, sir. We think, ladies and gentlemen, that after taking this proposal, one who should be found guilty will be, and that's something the opposition is never going to address by just keeping to the status quo. They have proposed nothing in order to change that, and we think that is a fundamental problem. No. There are two things I'm going to discuss in my speech. Firstly, I'm going to discuss whether the swaying judges, swaying juries kind of harm is actually going to happen. Ladies and gentlemen, what I'm going to tell you is that we think we trust the current system in order to achieve accountability and the ability of people to decide rationally. Secondly, I'm going to discuss the existence of a problem and how we think that it actually is going to be addressed by our proposal. No, sir. So firstly, in terms of their harms, they told us that there is a fundamental preconception that if you have done something in the past, you will commit again, and that is so fundamentally strong in everyone's mind, and therefore it affects every trial, ladies and gentlemen. They have the burden they have set up, have imposed on themselves, that in every case that would override every other evidence and everybody's rationality, which we think is not the case for a couple of very important reasons. Firstly, we think like this past criminal record is obviously not the only evidence that is presented in the court. Later on, let's sit down, sir. Well, it is obviously going to be used in conjunction and in comparison to other evidences. He has told us that, well, there is, it overrides things like fingerprints and alibis, ladies and gentlemen, and I don't think that happens, because everybody having rational minds, ladies and gentlemen, and you won't be selected as jury if you are proven not to be that rational in the first place. For example, when you have mental problems under these kind of situations, we think you will actually side with more physical evidences like alibis and fingerprints, ladies and gentlemen. So we don't really think that the overriding arguments really stand. And secondly, we think that if past crimes seem to be very irrelevant to the crime that you are committed in the status right now, in general, we think that will be actually considered and taken out of the court, ladies and gentlemen. For example, when the crime you have committed in the past is, for example, shoplifting, and the crime you are being charged for in the court right now is probably something like arson or rape, ladies and gentlemen. I don't really think that people will think that, well, because you have done something really pitiful in the past, you're going to commit these really big things right now. So I think the average people would think, well, what is the linkage? I don't really think that's relevant. No, sir. And then they told us, people will robbed of their rationality. Ladies and gentlemen, we think this is not true. We trust people's ability to make analytic decisions, and we think that it will be maintained by the accountability mechanism which happens in the courtroom for three reasons at least. Yes, sir.
Be specific. Does this kind of prior evidence of past crimes actually have an effect on the mindset of the judges or the jury that they give harsher sentences, or are they so irrelevant that we can add it and they would analyze it in context with other pieces of evidence?
Well, it depends, and we think it should be up to the people in the courtroom to decide, ladies and gentlemen. And we think we think what we told you is that maximum information always makes things better. If they think it is irrelevant, they would take it out of consideration. But when we believe that there are some cases in which this is probably one of the most important information, and in that kind of cases, we think it would be taken seriously by every jury and every judge. We think that's a distinction we're making. We think it still stands. So why do we think it is accountable, ladies and gentlemen? First of all, we think we trust the ability of lawyers to defend these people in the first place. Lawyers would defend the defend suspect with clear reasonings of why they think that the past criminal record is irrelevant if they really have confidence in it. Or they would point to how rehabilitation has been done on these people in the past. They would point to what good things they have done in the past and all these kind of things. And we think that would still be maintained. Secondly, they have told us that blacks are now given the ability to veto white people to become juries, but we think this is clearly different to this case, because in that case, well, we have to acknowledge the fact in places like the United States, lawyers are majorly coming from white background, ladies and gentlemen, so we don't trust the lawyer's ability to defend them superbly well, and we think that's a clear distinction. Whereas when it comes to evidences in general, every lawyer is an expert in it, they have every knowledge in it. No, sit down, we think we can trust this in this case, so we think it's different. Lastly, we think that circumstantial evidence is to some extent already considered in the court. People look at what kind of things they have done in the past. They look at whether alibis are circumstantial evidences, and that is considered in the court. Anyway, we have no problem with that. Lastly, we will say that this is completely different to things that the information that we eliminate in the court. For example, ladies and gentlemen, we eliminate information like the use of of gruesome images and gruesome videos, which which shows how brutal the crime was, ladies and gentlemen, because it affects viscerally on the juries, and therefore robs people ability to make rational decisions, ladies and gentlemen. Now sit down. And what's happening with our case is that you are allowed to look at the resume or documents which is written in really complex language, and we think that is quite different, and it is probably going to be analysed pretty analytically, not emotionally. We think that is a difference. So secondly, in terms of the problem, ladies and gentlemen, well, first of all, we think this problem of second offence still happens, even in the most progressive systems of rehabilitation like the ones in Norway. Second offence does happen, and I think they have conceded to it when they say that harsher punishment should be given in cases of second offences anyway, ladies and gentlemen. So it does happen. And secondly, we think our case is pretty relevant to cases, for example, where the situation behind the crime hasn't really changed, ladies and gentlemen. For example, there's someone who has been convicted of shoplifting in the past and has gone to jail and rehabilitated. Once he comes back, the situation of poverty hasn't really changed, ladies and gentlemen. No matter how much you were rehabilitated, and we think in some cases the poverty is going to be exacerbated by the fact that you have criminal records, ladies and gentlemen. Under this kind of situation, you're really likely to commit second crime. Well, what happens when there is no evidence but for the fact that you have committed a crime in the past cases, in the past history, to be given in the court? That is that in the status quo, these people are given no retribution, no ways to contribute back to the society, and there's going to be no compensation for the victims, ladies and gentlemen. We don't think that it's justice, ladies and gentlemen. After taking this proposal, when the judges can decide, based on the information that we're now adding by this proposal, we think that there is still going to be a difference. At the end of the day, ladies and gentlemen, we have told you that there is to some extent a linkage between past virtues and the current things we have done, and that is exactly why ICC takes this round. Thank you.
Thank you, Mr. Speaker. Look, ladies and gentlemen, house today. Today, what we believe from the opposition side, the government side, what they're trying to do is actually assuming that people. What they're doing is that saying people who actually commit crimes, they are guilty before they're actually being charged. So we believe that is actually infringing the right of being proven innocent, and then that's actually making them more likely to be condemned of crimes that they might not have done. And thus, for this reason, we believe this is unjust in the first instance, and we believe it's going to cause harm for those innocent misjudged. Thus, we're proud to oppose. Firstly, I'd like to today I have like three main refutations before I move on to my point / construction. Firstly, on this first point, he said that this kind of thing will not, because of providing this will not make the judges think irrationally. Now, if judges are rational enough to judge whether or not this piece of evidence actually relates to this or not. However, three rebuttals. First, is it related? First of all, I come with an example saying that shoplifting, case of shoplifting, and then saying then there's a murder. So there's no relation. So judge is not going to look at this. However, we don't believe this has any relevancy. My partner explained that the second punishment of the same crime would be more harsh, and that would be enough to actually make deterrence. So we do not believe that kind of thing should come in when making decision, because they're not related to the same case. And then secondly, even if the person committed the same crime, and even if the past crime is related to the current crime, we should not use that as an evidence in proving that whether or not it's innocent or not. If it's a number of evidence that you're lacking to prove this person guilty or not, get more evidence, find more fingerprints, do everything else, improve your police report. Ladies and gentlemen, that's what we should do. And then that applies the same thing with innocent men as well, ladies and gentlemen. People are innocent. If you don't have enough evidence to prove he's guilty, he should be free. That we are saying that even after you actually rehabilitate, you should consider it as an innocent man once and for all. And that is what the preconception of innocence should be, and thus we should uphold this by opposing this motion. And then secondly, and the third refutation on this point, even if Okay, that's even if that is someone related, and then we're actually charging the same kind of person. They come up with saying, attacking my partner's point, saying that this will not be an overwhelming decision to actually overrun the judge's decision. However, in times where the evidence are not that enough, the judge will think evidence is okay, but it's not that much. But then, oh, now we have a thing saying this person has committed crime before, so we can see then it's a flipping emotion. So we believe there's an effect. And if they say there's no, then what's the point of putting this anyway, right? Then what's the point of purpose of putting in this motion and then not have any effect on the judge's proposal? So on that part, we believe on these 3 points, that point about judges being rational and how they actually can make judging more fair does not stand at all. Yes.
Now, what we have told you is that it depends on the situation. In some cases, it makes difference, and in cases that don't, there is no harm coming from your side. So we think like it is necessary for some cases, and that you have to deny in the case.
In some cases, it does relate. In some cases, it don't. I already explained that in some cases, when it does relate, then it should just be up to the evidence in hand, not his past crimes. If that's something related, then what he's assuming in this case, ladies and gentlemen, is that the evidences, they're saying that the evidences for charging the person second offense is not sufficient to charge a person guilty, and thus we should add more evidence by saying that's past crime. So we don't believe that's actually unfair against the prosecutor, and that's what we say. We're actually putting this kind of person guilty before charge. We're saying you're guilty no matter what, and then if you're no matter what, ladies and gentlemen, and that is not good. And the second rebuttal, he came up saying like, to my partner's point, a second point, saying that, then we can, even lawyers cannot really persuade and actually counter preconception. What he's actually saying, he actually admits to the fact that preconception is a big deal in actually determining whether or not a person is guilty or not. So what they are bringing more preconceptional evidences, which just means there will be a greater chance of charging a person guilty. And in effect, an increasing chance of being guilty, the person might not be guilty. So that's when my partner's second harm comes in, because that person might be innocent, but then is charged guilty and then get a second punishment, which he should not get in the first place at all. So on that respect, lawyers, he actually actually supported our point. So, sorry. And then lastly, and on the third point, we must actually distinguish the difference here. We believe that person is actually innocent before every court case. And evidence at hand, evidence provided by the police, evidence provided by whatever information you can get, should be the main evidence when coming up to judging, and not what he's come with a crime. And then with his response to this third point, about his third point here says that because the person is from like a really bad background, that after you rehabilitate, he comes back, and then the same, so he still results in poverty. And he still commits the crime. How does that actually apply to this motion? First, I do not really see it clear. And secondly, if it's a circumstance economic situation, then we go and simulate and then have welfare and support these people, get out of poverty, if that is the root of the crime, the intentional crime. And secondly, the second offense, we believe that in the current system, is status quo. My partner mentioned again already that if you commit the same crime again, you get more severe crime, and that is where the deterrence comes from. Okay, lastly, move on to my last point. I feel you already. Sorry. No, sorry. Lastly, I would like to talk about how this actually can create it's going to make the government have less incentive to actually rehabilitate these people. Okay, first of all, we believe that government has perverse incentive to cut the rehabilitation time and quality if we take this proposal. If we continue on with their idea about because the past will commit crime, and thus they are easier to catch if we actually take this proposal, right? So in a sense, they believe there is this sort of like deterrence. So what we see is that, but however, the government would actually think that way, but the person whether or not committed a crime, it doesn't really have much to actually relate to whether or not he has committed crime or not, but actually his situation when he commits the crime. So the change of crime committed after rehabilitation does not really change at all. But however, the government, because of this, they see that it's easier to catch these people again. So then why don't we just catch them again after they got rehabilitated? So we just continue to catch them, and there won't be much of a problem afterwards. So there's no really need to rehabilitate these kind of people. And secondly, government does have like an incentive to cut the cost when it comes to these kind of things. When you see like these poor conditions in jails, it shows that government doesn't really have much effort into these rehabilitation programs already. And also that if it provide money to rehabilitation, this kind of money doesn't really have that much of a visible effect as if you build a bridge, as if you build something. And thus, they do not see as a incentive, they don't have that much incentive to have the cost, to actually put up the cost. So they'll actually cut the cost. So when we have the status quo, is that they have a long rehabilitation. Afterwards, we believe they're going to cut the rehabilitation program. But we believe the rehabilitation program is important. It's a time for them to stay and reflect on themselves. And it is a change in what they actually truly think and their mindset that what actually helped to deter the future crime, not the charge. So, for all these reasons, I'd like to oppose.
Mr. Speaker, ladies and gentlemen, this is my third time with Johnston in the grand final, and we've won the previous 2 grand finals. And we think we're going to win this third grand final as well. And if you believe that preconception, this debate was over before it began. You judge a debate you don't judge a debate based on preconceptions or circumstantial evidence. You judge a debate on the evidence we have provided to you, the reasoning, the analysis, and the logic. And we believe that preconceptions, like the ones which the proposition is trying to support, is just circumventing that. And it's it's cutting the responsibility of the state. So moving on to the 2 clashes in today's debate. Okay, now, first, the relevancy of prior offences. Second, does this compromise the presumption of innocence? Okay, now we never really got a clear prompt, right? Because they said sometimes it's relevant, sometimes it's irrelevant, it's for these people to decide. We believe we can already kick irrelevant out of the debate because it's unnecessary, right? So the question that we have to ask here, ladies and gentlemen, is how relevant does this become? How does prior preconceptions of past offences influence the decision-making process of the judge? We never really got a government analysis of that. But we gave you an opposition analysis. It turns grey circumstantial evidence into black evidence. Now, the assumption on side prop is that everybody who comes to court is guilty before the trial even begins. But that's not the case. It's the role of the state to prove the guilt in court. That's what it's essentially there for. But if all grey pieces of circumstantial evidence were preconceived to be black by this very ugly preconception, then there's no trial at all, ladies and gentlemen. It's always black. It's always guilty. It's always second, harsher offence. And we believe that this has, what we told you, 2 very adverse effects. 1, it allows the state to cut corners in providing crucial good evidence, which is the point we got from Leader of All. Because if they can provide preconceptions, then who needs DNA? Who needs fingerprints? All you need is somebody with a cock and bull story to say, I saw him committing murder, and then another guy to say, he's committed murder before. And that'll work right on, and that is enough to prove his guilt. But that's not the role of the state. Because, to the second point, does this compromise the presumption of innocence? We believe it does. Because, again, if for propositions, ideas and benefits that come into place, these preconceptions have to work and have to be relevant. And we believe that there's no government analysis. It works in our way. It works to turn grey circumstantial evidence into black, which means that we compromise presumption of innocence. It's the role of the state to prove that this person is guilty. It's not the role of the individual to prove that he or she is innocent. It's not, everything is stacked against the state. And we believe that this is one reason to compromise that. This is one reason for state to slacken in its duty to provide a just legal system. So we believe, Mr. Speaker, what we are doing in their model is nothing but proving people black. if they want to talk about the benefits that they've talked about in Prime Minister, which essentially they seem to have kicked out in Member of Government because they never mentioned it, it's about sentencing, ladies and gentlemen. We already give harsher punishment. Why not just increase that if you want to do everything that the government has propped to you so far? Mr. Speaker, we believe, as I told you again, in the integrity of our legal system, and we rely on absolute evidence to make the judges to make the right decisions. And we are taking that cup home.
Judges, please look at your notes and judge fairly, and I know you can, unlike Nick's analysis of irrational judges all over the place. Now, we think that there are states which doesn't reflect past crimes to the proportionality of punishment of the sentences right now. And even if all of the liberal democracies reflect that already, there still is a problem under the status quo, because there are criminals who are able to run away from punishments, who are able to run away from justice, because not all courts have full evidences, not all courts have DNAs and fingerprints. Some courts doesn't have entire and full access to circumstantial evidences, and therefore the juries has to decide that, well, this person is innocent. But the problem is these criminals commit crimes over and over again, and there is a massive harm caused by those crimes. And therefore, because we believe that it is more important the mere possibility of wrong punishments being given, we are still proud to propose. Now, let me firstly engage with Johnson. He said that rehabilitation process would be deteriorated because governments would have less incentive to fund that. That's wrong, because any liberal democracies, any societies have an incentive to prevent further crimes. That's why any governments allocate money towards rehabilitation process, having these psychologists in prison so that rehabilitation occurs. Now, we are talking about criminals who are not properly rehabilitated. Regardless of these efforts made by liberal democracies, there are still criminals which is not rehabilitated. And our policy would be able to bring about justice to these particular kinds of criminals. Let's summarize this debate from two questions. Firstly, will judges be swayed? And secondly, which side can prevent further crimes? Nick told us that presumption of innocence is important, and this policy would destroy that, because judges would be emotionally swayed. We do not believe it. Hide-san spent like 5 or 6 minutes explaining how that's not the case. Firstly, if crimes of the past are so different, then obviously juries would not take that into consideration. But when there's a strong correlation, as I have told you in my Prime Minister's speech, then that is when judges would take into consideration. If the victims of rape is really similar, like age group or the hairstyle or body look is so similar, maybe these juries can decide that maybe this defendant, or surely that this defendant has committed a crime. When there's a strong correlation, judges decide. Now, secondly, as Nick told us as well, that there are other factual evidences as well, which Hide-san told you can be mixed with past crimes and can be taken into consideration. And thirdly, we've told you that rationality is maintained, where there's a long discussion, as I've told you in my PM speech, long discussion where courts are held in long time, and there are constant debates between prosecutors and lawyers. And therefore, we believe that rationality in majority of the cases are maintained to necessary extent. Now, second question is which side can prevent crimes? Because opposition as a whole has also agreed that preventing crime is really important. And the opposition didn't engage to our analysis of how our policy deters people and also how our policy brings about justice. We've told you that if we're talking about rational crimes, obviously they would be deterred. But we don't have to rely on the fact that deterrence power would work, because our policy would surely be able to bring about justice towards these second offenders, sexual crimes, or even white-collar crimes, which is still serious. Those we are able to prevent further crimes and further victims. At the end of the day, ladies and gentlemen, Nick just asserted presumption of innocence. It seems like a really important principle, but he have never told us the importance of that. We on the government side told you that massive harms, irreversible and traumatic harms caused by crimes should be brought about under justice. And for that reason, we're still proud to propose.
I thank the Prime Minister. Our speech is over. Thank you for your nice cooperation.